The death penalty in the United States is at the same time a pretty simple issue and a very complicated issue. From the view of the Catholic Church, the death penalty is an affront to human life and dignity and should be abolished. From the view of the legal system, the death penalty is a well-established, constitutionally permissible punishment, as long as it's reserved for the worst offenders and applied in an even-handed manner. From the view of the American people, the death penalty is an increasingly unpopular and infrequent penalty that makes many people uncomfortable. My job today is to impart to you some basic knowledge about the death penalty so you can begin to assess its legality, its utility, and its morality. So let's get started with the basic legal framework around the death penalty. The Eighth Amendment to the U.S. Constitution prohibits cruel and unusual punishment. As a general matter, the Supreme Court has held that the death penalty for murder is constitutional and does not violate the Eighth Amendment's prohibition on cruel and unusual punishment. The Supreme Court has said that punishment should be proportional to the offense, and you determine proportionality by looking to evolving standards of decency that embrace and express respect for the dignity of the person. And so the court looks to society's standards as expressed in law and state practice, as well as the court's own independent assessment of the proportionality of the death penalty and the extent to which death will have a retributive and deterrent value. So what does that mean for capital punishment? The Supreme Court says, as a general matter, the death penalty for murder is constitutional and doesn't violate the Eighth Amendment. But it must be limited to those offenders who commit a narrow category of the most serious murders and whose extreme culpability makes them the most deserving of execution. So this raises two related questions: what crimes and what criminals? With respect to the question of what crimes, as I've said, the death penalty can only be used in murder cases. The question was whether it could be used in rape cases as well, and the Supreme Court has held that it cannot be. Death is a disproportionate punishment for both the rape of an adult and a child. What criminals? Even in murder cases, certain categories of offenders are not eligible for the death penalty. For example, a prisoner who is insane at the time of the proposed execution, meaning a person who is not aware of the punishment that he's about to suffer and does not understand why he's going to suffer it, cannot be executed. Similarly, an offender who is mentally retarded cannot be executed. Mental retardation is a term used in Supreme Court cases and is defined by the law of every state. Another example is an offender who is a minor under the age of 18 at the time of the offense. A minor offender cannot be executed. You have to have a death-eligible case, and each state's law designates by statute which types of crimes are eligible for the death penalty. At that point, the prosecutor's office has to decide to seek the death penalty in a particular case. Once the case goes to trial, there are two phases. The first is the guilt phase, and the question there is, did the defendant actually commit the crime beyond a reasonable doubt? Then, if the defendant is convicted of the capital crime, it moves to the penalty phase, which is a second trial where the question is, should the defendant be sentenced to death? At that trial, the government has to prove aggravating factors, which might include that the offense was committed in an especially heinous, cruel, or depraved manner, that the murder was committed during the commission of another felony, like kidnapping, robbery, rape, or arson, that a police officer was the victim, or that the defendant himself poses a substantial and continuing threat of future dangerousness or is likely to commit continued acts of violence. Once the government proves these aggravating factors, the defendant can demonstrate any mitigating factors at all, things that would show that he should not be sentenced to death. That showing generally focuses on the defendant's background, so that the person has had a very difficult life or suffered child abuse, for example. Perhaps the defendant would show that he has a diminished mental capacity or that he has no prior criminal record. At that point, the finder of fact makes a discretionary moral judgment that the defendant and the crime in fact warrant the death penalty. If the jury makes the opposite finding, then of course the defendant is not sentenced to death. Capital cases are very difficult to litigate. Prosecutors operate under a microscope, and there's often public pressure to convict the defendant. Defendants require experienced lawyering and also investigators who can look into not only the facts of the crime, but also the mitigation case. All criminal defendants have a right to counsel at trial for capital murder, as well as on their first appeal, including having a state-funded lawyer if the person can't pay for one. The problem is that many lawyers are not qualified to take capital cases, and even ones that are qualified are insufficiently compensated and are given insufficient funds for investigation. It's common for criminal defendants, including those sentenced to death, to claim that their lawyer was inadequate or that the prosecutor engaged in some kind of misconduct during the trial. For example, failing to disclose exculpatory evidence or stacking the jury with regard for race. And so, after the conviction becomes final, a series of post-conviction opportunities in the state and federal courts, called habeas proceedings, allow the defendant to make constitutional challenges to his conviction. Courts tend to take a closer look at capital cases on the theory that death is a different and more extreme penalty than any other. But counsel is not guaranteed in the habeas phase, much less investigation, and some people on death row have a difficult time finding counsel that will represent them for no cost. Now let's talk about statistics regarding the death penalty. It's a state-by-state decision whether to permit the death penalty as a matter of law. And so the information that I'm going to give you is current as of 2019. 29 states plus the federal government permit the death penalty, although 4 of those, Colorado, Oregon, Pennsylvania, and California, have an explicit moratorium on executions. There are, however, only 13 states that are actively carrying out the death penalty, by which I mean that they've executed someone in the past 5 years. 21 states plus the District of Columbia do not have the death penalty. Some, like Maine, Michigan, and Wisconsin, have never had the death penalty on its books. Some have abolished it more recently, like New Hampshire in 2019 and the state of Washington in 2018. When you add it all up, this means that executions are rare or non-existent in most of the nation. There are 37 states in which there have been no executions in the past 5 years. As of 2019, there are a total of 2,673 people on death row in the United States. There are 3 states whose death row populations are the most substantial: California, Florida, and Texas. Of those, only Florida and Texas are actively executing people. As I mentioned, California, although it has the biggest death row population at 732, has a moratorium on executions. Who's actually been executed? Since 1976, when the Supreme Court held that the death penalty was in fact a constitutional penalty, 1,505 people have been executed. Texas, far and away, has executed the greatest number of people, 548 to date. Where are most of the executions happening? The answer is across the South, about more than 80% of the total number of executions. Texas and Oklahoma alone count for almost 45% of the total executions in this country. But it's a bit misleading to look just at the states, because even within states, the death penalty is utilized in only a handful of counties. There are 20 counties, 11 in Texas alone, that account for about 36% of executions in the United States. These counties represent less than 1% of the total number of counties in the country, and less than 1% of the total number of counties in states with the death penalty. The top 5 counties that execute people, 4 of which are in Texas, they alone account for over 20% of the executions. What does that mean? It means that when you commit your crime, it turns out that where you commit your crime affects the likelihood of receiving the death penalty. Now, what's the intersection of the death penalty with race? First of all, we can look at who is on death row, who has been sentenced to death. 42% of the death row population is white, 42% is African American, and 13% is Hispanic. What about who has been executed? 56% of those executed have been white, 34% have been African American, and 8% have been Hispanic. What this means is that African Americans are overrepresented in both categories of who's been sentenced to death and who has been executed, relative to their share of the U.S. population in general. African Americans constitute only 13% of the general U.S. population, but 42% of those sentenced to death have been African American, and 34% of those executed have been African American. This racial disparity, of course, is endemic to the U.S. criminal justice system, where about 37% of the total male prison population is African American. Studies have shown that one key factor in determining who gets executed is the race of the victim. Over 75% of murder victims in cases resulting in an execution were white, even though nationally only half of murder victims generally are white. How common a penalty is it to be imposed and to have carried out? It turns out that the number of executions and death sentences have both dropped dramatically since 1998 and 1999. The number of executions in this country peaked in 1999 when 98 people were executed. There's been a relatively steady decline since. With respect to death sentences, that number also peaked in 1998 when 295 people were sentenced to death. And again, there's been a steady and fairly substantial decline since. These data show that executions are likely to keep declining because juries are handing out fewer death sentences. Why is that? Why are we seeing a major downturn in both death sentences and executions? The biggest factor is probably the availability of a sentence of life without parole. In every death penalty state, life without parole is an alternative sentence. Juries are getting the choice of death or life without parole in virtually all death-eligible cases, and they're increasingly choosing life without parole. That's a major statutory reform that's had an effect on the death penalty. Relatedly, prosecutors are increasingly likely to seek life without parole now that it's available. They see life without parole as a better alternative because capital cases are expensive to litigate. There are 2 trials in one, the guilt phase and the penalty phase, plus a lengthy appeals process. Plus, this cost of extra security on death row makes death cases much more expensive. For example, Colorado once spent $18 million litigating a death penalty case that went all the way up to the Supreme Court. And studies have shown that it's significantly more expensive to litigate a capital case as opposed to a case where the penalty is not death. On average, $700,000 more than a non-capital case. And so these extra costs of the death penalty beyond life sentences often cost $10 million per year per state on average. Another factor contributing to the downturn of death sentences and executions is logistical challenges related to the availability of execution drugs. Most states have used chemicals in recent years to carry out lethal injections. In 2009, for example, the supply of one commonly used anesthetic called sodium thiopental ran short because the only manufacturer in the United States ran into manufacturing issues at its North Carolina plant. It tried to resume production at a company plant in Italy, but Italy refused to grant permission if the drug was going to be used for executions. And so states have had to adopt new lethal injection methods that have been challenged legally and led to some botched executions. As a result of these supply chain issues, some states have had to suspend executions. As the number of executions has gone down, so has public support for capital punishment. In 2018, 54% of the American public supported the death penalty. This marks an overall decline in public support over the past 20 years. Interestingly, though, support for the death penalty is up in 2018 from where it was in 2016. In 2016, polling showed that the support for the death penalty had dropped below 50%, which was an all-time low, but it has since ticked back up. Support among Catholics for the death penalty tracks public opinion pretty closely. 53% of Catholics support the death penalty. Still, everyone agrees there has been a big decline in public support for the death penalty over the past 2 decades. Why might that be? People cite 2 primary factors. The first is exonerations, where we know that an actually innocent person has been sentenced to death. That has shaken public confidence in the capital punishment system, and indeed 71% of the public thought there was a risk of an innocent person being put to death. Since 1973, 166 people have been exonerated and released from death row in 28 different states, and that figure is current as of 2019. Since 2000, there's been an average of 5 exonerations per year from death row. Florida is the state that has had the highest number of exonerations from death row, 29 in all. Another factor that contributes to the decline in public support for the death penalty is a concern that the death penalty doesn't actually deter serious crime. Research has shown that this is in fact true. And indeed, among the 25 states with the highest murder rate, 20 have the death penalty. States without the death penalty have had consistently lower murder rates. The final topic I'd like to address is the Catholic Church's own teaching on the death penalty. In August of 2018, Pope Francis modified the Catechism of the Catholic Church to categorically reject the death penalty. This was a significant change because before this, the Catechism had allowed that the death penalty could be permissible if it was the only possible way of effectively defending human lives against an unjust aggressor. St. Pope John Paul II in 1995 started the momentum that led to this change when he stated that cases in which the death penalty was the only possible way of effectively defending human lives are, quote, very rare, if not practically non-existent. And thus, he said, the death penalty was almost always impermissible. In 1999, during a Mass in St. Louis, St. Pope John Paul II called for an end to the death penalty, which is both cruel and unnecessary. Pope Benedict also endorsed efforts to eliminate the death penalty. Pope Francis continued those calls, but shifted the emphasis from a utilitarian objection, the death penalty is unnecessary, to a dignitarian objection. The death penalty violates the inalienable dignity of the human person, even those who have committed grave crimes. For example, in October 2017, Pope Francis presaged the revision of the Catechism when he stated that the death penalty is an inhuman measure that humiliates personal dignity in whatever form it is carried out. And it is, of itself, contrary to the gospel because it is freely decided to suppress a human life that is always sacred in the eyes of the Creator, and of which, in the final analysis, God alone is the true judge and guarantor. Thus, the newly revised Catechism of the Catholic Church now states, recourse to the death penalty on the part of legitimate authority, following a fair trial, was long considered an appropriate response to the gravity of certain crimes and an acceptable, albeit extreme, means of safeguarding the common good. Today, however, there is an increasing awareness that the dignity of the person is not lost even after the commission of very serious crimes. In addition, a new understanding has emerged of the significance of penal sanctions imposed by the state. Lastly, more effective systems of detention have been developed, which ensure the due protection of citizens, but at the same time do not definitively deprive the guilty of the possibility of redemption. Consequently, the Church teaches, in the light of the gospel, that the death penalty is inadmissible because it is an attack on the inviolability and dignity of the person, and she works with determination for its abolition worldwide. This very brief overview is meant to provide information on the legality, utility, and morality of the death penalty, especially from the perspective of the Catholic Church. I hope you have found this helpful and as a way of starting conversation amongst yourselves. Thank you for your time and attention.